Get started.
Sit up.
All right.
Sit up. Sit up.
All right. Welcome to the Judicial Proceedings Committee. Today's Friday, February 23rd, 2024. We're going to start off with voting list number 6. And we're going to start off with Senator Benson with Senate Bill 36, and that is Josh.
Senate Bill 36 establishes the Maryland Deaths and Custody Oversight Board. So there is an amendment in your packet. It's number 473720/1. The amendment strikes the entirety of the bill and instead adds a requirement that the Department of State Police report on investigations they do of suspected homicides of incarcerated individuals. So it's currently a requirement in the law that MSP investigates those deaths. And so with the amendment, the bill would simply add a reporting requirement for those investigations. There is one minor change that needs to be made to the amendment. So if you're on the reprint, it's page 7 of 7. The language in the bill is currently refers to investigations conducted by the Department of State Police. It should say completed by the state police. Correct.
This could be similar to the IID that they put like a dashboard on their website or something like that. Is that right?
Yeah.
All right. Sorry, Senator Fulton.
So being clear, the whole bill was struck and now we've just made an amendment.
Correct. So
Can
it's
we-
just the reporting requirement that's in the bill now.
So are we allowed to make a request to hold the bill because so we can review the amendment? I mean, it strikes the whole thing.
Yeah, just fairly straightforward amendment, but you can hold the bill if you want to request to hold the bill, still got enough time, but it's a,
I mean,
just hold on. Yeah, come off mic.
I
if you-
think they already do a report though, right?
So but they don't publish it.
Uh,
They were fine with the amendment.
Okay.
MSP was fine with it.
All right. Okay. I'm good then.
All right, so I'd like to move the amendment. Is everyone okay moving the amendment?
Yep.
All right, now Senate Bill 36 is before you as amended. Motions for favorable with amendment. It's been seconded. Is everyone okay being recorded in the affirmative? Senate Bill 36 with amendment passes unanimously. We'll now move on to Senate Bill 42, which is also Josh.
You want to just say more work or want me to explain it?
Yeah. Actually, hold on. Yep, we're going to hold Senate Bill 42 as we enter there's some forthcoming amendments and discussion. So Senate Bill 42 is on hold. We're now on to Senate Bill 71, which we're also going to hold. I have some forthcoming amendments. Also, the sponsor is not here, so we'll hold that bill 71. Senate Bill 92. There are still some negotiations going on, so we are going to hold Senate Bill 92. Senate Bill 100. Let's just go ahead and discuss, but it is going to be held because there are still some forthcoming amendments. But at least we haven't discussed this one yet. So Jamie, if you can go ahead and discuss it.
So Senate Bill 100 establishes the offense of organized retail theft of property with an aggregate value exceeding $1,500. A violation of this prohibition is a felony punishable by imprisonment for up to 5 years and or a $5,000 maximum fine. A person who violates this prohibition must restore property to the owner, and if unable to restore property to the owner, pay the owner the full value of property. A conviction for organized retail theft merges into a conviction under the general theft statute for the purpose of sentencing, where the two convictions arise from the same acts or transaction. The bill also clarifies the venue for prosecution of a case involving multiple thefts in multiple counties committed by the same person under one scheme or continuing course of conduct. So those acts that occur in different jurisdictions may be joined for trial and prosecuted in a single county.
So I know we're holding this so that can be more discussion. I really think this is an important bill. But it's the kind that engenders lots of conversation in this committee. So if folks have concerns, definitely let me and council know, or the chair, on this bill. The chair and I were at an event. I had to grab something on my way home across the street from the event. I walked into CVS. The event actually that the chair and I were in attendance of. I was at Juvenile Justice. I went to CVS across the street to grab something for my wife. What's that? Well, yes, to purchase something. There were a number of juveniles who entered clearly with the intent, and I just decided to stay and observe what happened. And it's a scary thing when this happens. It's scary when you're in the store. It's scary for the staff. And it was very clear these gentlemen had a lot of experience doing this and had a plan when they went in. And so all this bill does is allow them to take everything that happens across a number of these that happens over different jurisdictions and do them in one trial. There will be a question coming up whether we want to aggregate the dollar figure or not, or whether it'll be multiple charges just handled in one jurisdiction. I think in Senator Kelly's district, a bunch of places were cleared out. I think actually a bunch of CVS's. I think one of those actually might have been in my district, right on the line between me and Senator Kelly. But they did, I think, 4 or 3 of them in the course of 2 hours. And I don't know if one of them was in a different jurisdiction. Maybe they were all in Montgomery County, but it could have been over multiple jurisdictions. Anyway, just stuff to think about as we enter the conversation about this bill.
Senator.
I very much support this bill, however it comes up. And I don't know if you all saw the recent Washington Post article where, unfortunately, I think it was a Walgreens, the manager and then another manager and their family were basically involved in organized retail theft. So, right. But oh my,
which is, I mean, it's not
Right.
surprising, but it shows you how dangerous these
right,
things
because
are.
this is no
The
longer,
security guard, I apologize.
no,
for
no, go
interrupting.
ahead.
This was the 7th robbery.
Yes,
By the same people of the same Walgreens. Now, this
Right.
was in the District of Columbia, not in Maryland,
right,
but the security guard eventually got scared enough that he shot the robber.
right.
And that's not, I mean, that's it's dangerous for everyone. The
Everyone.
robber could have shot back,
I know.
whatever. So
Right, you're right. So not only is it theft, it's just not shoplifting as we once knew it, but it has violent. So I was only going to ask you, did this bill have opposition? Because I don't have it in my bill file. And just because we're having a discussion, and of course I'm saying I support the bill, but I didn't see any, I'm not saying some individual didn't oppose it, but I'm just saying I didn't see anything in writing. Oh, well, yes, right, the public defenders, of course. Right. Okay, thank you.
In talking about our position and again, I think I mentioned to the sponsor that I support the concept of the legislation as well. However, they do point out that the concept of one scheme is overbroad and vague. So whatever it is as we move forward, I hope that we can tighten that up. That was one of the main concerns that I just wanted to express.
So this bill is, thank you, Mr. Chair. This bill is vitally important. It's about what this Senator Waldstreicher brought up. These victims people are victimized that aren't even the intent of the theft. They're put in fear. And I can tell you that as firsthand accounts that I have been a part of investigations that have spanned counties, in the single incident where someone left Baltimore, they went through Montgomery, a Walmart or a Target. Then they went to Frederick, hit both Walmarts, then went to Carroll County, hit Walmart, and looped right back in. So, and in doing that, it's numerous people rushing in, grabbing stuff, putting people in fear, running out, creating a very dangerous, chaotic situation outside with all the traffic. It's just something, this is time, it's really necessary, and I fully support this bill moving forward. So thank you.
Yeah. Actually, no, I completely agree. I mean, look, I support the bill as well, so we've got a couple things to work out, but I fully intend in supporting it with my vote. So I think we hold it. We're going to vote again potentially twice next week, so we'll have time to do that. So all right, we'll now move on to Shamari with Senate Bill 125. I know that there are two amendments in the packet, but there is a work group amendment that we'll consider first, which I know that we've discussed. So I'd like to make a motion to adopt that amendment. Can we just read off the amendment number? So it's
And so the amendments by the work group is amendment 783-027 in your packets.
/1. My motion is to adopt the amendment. It's been seconded. Is everyone okay adopting the amendment? Now the bill is before you as amended. Motions for favorable with amendment. Is everyone okay being recorded in the affirmative? Excellent. Senate Bill 125 with amendment passes unanimously. All right, we're now going to move on to Senate Bill 162.
Senate Bill 162 expands the circumstances under which a tenant's liability for rent may be limited when vacating a premises due to medical reasons by one, specifically extending applicability to individuals with an intellectual disability or developmental disability or mental disorder who meet certain requirements, and two, authorizing additional licensed professionals to complete the necessary certification that a tenant must provide to the landlord. There is an amendment in your packet. This amendment is identical to the amendments adopted by the House. The first amendment removes a therapist as a professional who can certify a person as having a mental disorder that would allow them to vacate leased premises. Amendment 2, if you look on the reprints onto page 2 of 3, it alters the certification form that the physician or psychologist must sign in order to authorize an occupant to leave the leased premises.
All right. So the motion is to adopt the amendment. It's been seconded. Is everyone okay? All right. Now the bill's before you as amended. Further discussion. Motions. Motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 162 with amendment passes unanimously. We'll now move on to Senate Bill 174.
Senate Bill 174 extends from 60 to 120 days the period during which the holder of a non-commercial driver's license may be out of compliance with the child support order before the Child Support Administration is authorized to notify the Motor Vehicle Administration to begin the process to suspend the obligor's license. The bill also alters procedures Child Support Administration must take before notifying MVA of an obligor's non-compliance, including requiring the CSA to petition the court to make a finding after a hearing that suspension is appropriate as specified, and 2, permits the obligor to make a request for reinstatement of the license with CSA or the court. 3, requires CSA on the request of the obligor to request for MVA to expunge an obligor's record of license suspension for failure to pay child support as specified. And 4, prohibits CSA from using a randomized lottery system to select obligors for the purpose of notification to MVA. And so there was an amendment recommended by the AG's office. Senator Muse had emailed me this morning, and there's amendments we're still working on getting those finalized.
Okay. So do you want it? I don't know if I'm not privy to those amendments because I know there haven't been.
The amendments in the packet are from the AG's, but Senator Muse staff
there
emailed
more
me
amendments?
this morning that there's.
Got it. Okay. Understood. Okay. Sponsor wants to hold, so we'll hold. So then we will not adopt this amendment. We're going to wait for the other amendments.
Yes.
Okay. Yeah. All right. So we're going to hold Senate Bill 172.
174.
174. My apologies. Yeah. All right. The lottery system thing is crazy though. We should fix that. That's like so dumb. All right. We'll now move on to Senate Bill 182. Josh.
So also B and T on this. Yeah. So Senate Bill 182 establishes requirements, procedures, and prohibitions to govern the use of facial recognition technology by law enforcement agencies and courts.
So there are a couple of bills, 5 bills that we have that need, because of their fiscal notes, they need B&T approval. I've submitted requests for approval on all of them. That's Senate Bill 71, Senate Bill 471, Senate Bill 774, Senate Bill 182, and Senate Bill 398 have all been submitted for approval. So we're just waiting for a decision one way or another, then we can move forward with it. So we're not holding it just to hold it. And I'll report back to you all. So Senate Bill 182 is held. We'll now move on to Senate Bill 273.
Senate Bill 273 is a departmental bill that prohibits a person from intentionally photographing or recording images of a correctional facility through the use of an unmanned aircraft unless authorized to do so. The bill also prohibits a person from using an unmanned aircraft to deliver any contraband to a person detained or confined in a place of confinement. A violation of either prohibition is a misdemeanor, subject to a maximum penalty of 3 years imprisonment or a $1,000 fine, which is matches the current penalty for delivering contraband to a correctional facility. Correctional facility must post signage warning of the bill's provisions on the exterior of the property in an area visible to the public.
I mean, if the Department of Public Safety and Corrections does what they said they were gonna do, it may not be a problem, but I mean, administrations change. I still have the concern of facilities that are right in the middle of Baltimore City, and someone having the ability or essentially being prohibited from using their unmanned drone in their own community. And I had not had enough time to even think about how to amend it. I mean, I get it. I know why they want to do it, but I'm just concerned about those in that community. And I don't have, like I said, haven't had time to figure out how to deal with that one as of yet. If you don't mind, that'd be a good idea.
273 is held. We'll now move on to 282.
Senate Bill 282 is a departmental bill that repeals duplicative items from inclusion in GOCAP's annual report to the General Assembly on opioid use disorder treatment by local correctional facilities.
All right, I know there's interest in holding it until we figure out what about the funding. Still same tune as before. I will follow up with the relevant committee for the funding inquiry. All right, now we'll move on to Senate Bill 319.
Senate Bill 319 repeals the requirement for the Maryland State Commission on Criminal Sentencing Policy to report to the governor and the General Assembly each October 1st on the number of charges and convictions and sentences for violations of the prohibitions on wear, carry, or transporting a handgun and restrictions on possession of regulated firearms. It instead requires the Department of State Police each October to report that same information. There is an amendment in the voting packet from Senator West to shift that responsibility from DSP to instead be the Maryland Judiciary. A little bit of background on the bill. Evidently, and Senator West, I'm going off of information you provided at the hearing, but evidently the Commission on Criminal Sentencing Policy had advised that they actually don't have the information that's required for the report, which was shifting it to DSP under the bill. DSP subsequently advised that they don't have the information. Instead, the state judiciary does have the information.
To me and said, we're going to solve your problem. We have the information. We'll do it.
And I,
It's the first time that's ever happened.
That's great.
I do want to point out there's a rather high fiscal note on the bill as drafted. I'm not sure, and I had reached out to Kelly O'Connor just this morning. I had just flagged it while we were sitting here, but I don't know if we have an estimate on what the amendment would do to their fiscal impact, but it was around 580,000 in the first year for.
Well, when I was at the meeting of the criminal sentencing policy last summer, they said it was going to cost them a fortune to do it. They're going to have to hire staff. Since the judiciary already has the information, whatever the fiscal ramifications are, it'll be beneficial to the state than the current law, which would require the Criminal Sentencing Commission to hire a lot of staff to do this work.
And just for the committee, I would point out that the fiscal note does point to the high fiscal note being attributable to DSP having to reprogram its systems and hire additional staff. So
It doesn't exist, but yeah. So, Senator Fulton, what I'll do is
So I just want to be clear that, so the judiciary says that they'd be able to capture the number of charges. And then it says the convictions and sentences. So even if the charges are removed or dropped, like they're still going to capture that data. Because I know a lot of times they will merge or they'll null pros certain charges to go for a larger charge or whatever. And I just want to make sure that we're not minimizing data by not including all charges regardless of adjudication. And some of those I worry that, because some of that might be handled by the state's attorney and merging charges or doing something like that, making their own discretionary decision. So that then comes to, would that even be known by the judiciary?
So that's certainly, I mean, I'm gonna definitely follow up with the judiciary on the fiscal impact side of it, but and that's a question that I can raise with them too. Just so I'm clear on it, is the question, if a charge is initially filed with the court, there's an indictment or an information filed, but subsequently it's dismissed or null prost, or they just go with they plead down to something else. Would that charge still be included in the data even though it wasn't pursued?
Correct. Because the important matter, and I have one more point, but the important issue we're facing is that we have skewed data that doesn't reflect the actual time of arrest. This is what we're trying to show, is the number of engagements between law enforcement, the community, relative to regulated firearms. And then to that point, one thing that I see missing is it says by race and gender, but we're not including age, whether it's a juvenile or by age group. Like, I would think age group is also important in this because of the recent surge we've seen with juvenile violence around firearms.
I can definitely get the information about how the data is going to be reported as far as what's included in that chunk for charging. I think as far as disaggregating further by age is going to be a policy decision for the committee to decide whether to include that as a requirement for the report.
I think that's relevant too. I mean, and also just ensuring that the charges or pleas or whatever, it's not just final disposition. It says charges, but that, I don't know what that means in terms of.
Correct. And I have the same concern.
Yeah.
So,
and age, I would
I think
add that
17 and under would capture what we're trying to do, and then like 18 to 25, because that's our most critical.
the more information, better for
Yes,
us.
absolutely.
I mean, so, depending on what we do with the law in terms of, just because what I'm going to do is I'm going to contact the judiciary to see what fiscal impact this will have, Senator West, and then maybe we can be more prescriptive in the reporting requirements. We can work on that. Could you work with Senator Fulton on that? Sure. All right. Awesome. All right. Yeah, let's hold the bill without this amendment, because we're probably going to amend this again. So we want to adopt the amendment. All right. So Senate Bill 319 is held. We're now going to move on to Senate Bill 354.
Senate Bill 354 establishes the Rent Court Workforce Solutions Pilot Program in Montgomery and Prince George's counties. The programs are to provide workforce resources and information on workforce development and employment opportunities, specified individuals and failure to pay rent cases. In fiscal years 2026 through 2028, the governor must include in the annual budget an appropriation of $200,000 to be used for the pilot program as specified. Bill takes effect June 1st, 2024. There's 2 delegation letters in your packets, and there's also an amendment. Amendment 1 alters the purpose of the pilot program to include registered apprenticeships and changes to the designated organization instead of the county executive as the recipient of the $100,000 appropriation. Amendment 2 changes the requirements of the district court from shall to may for allowing designated organizations to operate within the courthouse. And it allows for the relationship between the designated organization and the court to be governed by a memorandum of understanding.
So just real quick, Senator Walsh, does your amendment include the other 2, or do we have to adopt all 3 or 2? Which one's a?
I'm sorry, I should have divided them. So Senator Rosa Pep's amendment, that's 503-523/1. That amendment is the one that adds registered apprenticeships to, yeah. And then Senator Waldstreicher's amendment, and Senator Rosa Pep's also moves the appropriation to the designated organization instead of the county executive. That's Senator Rosa Pep's.
So amendment 503-523/1 is motion to adopt the amendment, and it's been seconded. Is everyone okay? Okay, so let's move on to the next.
Okay, so the second amendment, that's amendment 703-723/1. That's sent by Senator Waldstreicher. And that's the amendment that changes the relationship from shall to may for allowing one representative from a designated organization to operate in the courthouse and allows the relationship to be governed by a memorandum of understanding.
Motions to add the amendment. Is everyone okay? All right. Okay. Okay, now the bill's before you as amended. It's been seconded. Further discussion? Is everyone all right? It's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 354 with amendments passes unanimously. We'll now move on to Senate Bill 373.
Senate Bill 373 generally prohibits the knowing and willful theft of mail or an arrow key or other device used to gain access to a mail depository. The bill also establishes graduated penalties based on the number of intended recipients for the stolen mail, the type of information contained in the mail stolen, or the status of the intended recipient of the mail stolen as an elderly person or disabled person. Conviction for violating any of the bill's prohibitions does not merge with a conviction for any other crime based on the acts establishing the violation.
So we're working out the final language with the House and we should have it soon. So I would request a hold, but if anyone has any thoughts on this bill, concerns about how it's drafted or the concept, please let me know before next week.
So we'll pass this bill only if there's if you give a little bit of the history of this. It's just on the floor. I think it'd be awesome. Yeah. All right. Now we're going to move on to Senate Bill 391. There we go. What do you want to do? Move it?
Oh, sorry.
Oh, no,
I didn't know someone was gonna remind us what the bill does, but I would love to move the bill. Yes.
So Senate Bill 391 establishes that an individual may be prosecuted at any time for a violation of the following sections of the criminal law article. Sextortion under 3709, stalking under section 3802, and revenge porn under 3809. So it sounds like there are two conceptual amendments to be offered. I'll defer to Senator Kelly or the chair.
So after speaking with a number of members of the committee, I think that the committee will be comfortable, tell me if I'm wrong, but I want to make sure everyone is comfortable with this bill as it moves out of committee. It would be comfortable with unlimited statute of limitations on revenge porn, 5 years on sexual extortion, because that's consistent with the extortion statute of limitations. And I believe 10 is where we are pretty comfortable on stalking. I think it's really important we make stalking as long as possible, but I think 10 is where people are most comfortable. It's most important to me that we move this bill out. I spoke with the House sponsor, and I know that they're considering this over in the House side. And I just want to make sure that since we're making changes on this, we get it out quickly so that we don't get into one of those ping pongs back and forth with the two chambers where we have different opinions and we have a dead women's rights bill on sine die, which has happened year after year after year. So with that in mind, I think the conceptual amendments that I think the chair can describe a little better, but I'm okay with them.
No, you're spot on. I couldn't agree with your sentiments more. So I'd like to motion for favorable for those two conceptual amendments. All right, seconded. Everyone's okay. Now the bills before you as amended. Motions were favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Senate Bill 391 with amendments passes unanimously. We'll now move on to Senate Bill 397.
Senate Bill 397 establishes standards and procedures for the registration of a military vehicle as defined in the bill. The bill requires all such vehicles that meet the criteria in the bill to be registered as a Class MVC, Military Vehicle Collector's Vehicle, and establishes a one-time $51 registration fee. The bill is identical to Senate Bill 748 of 2023, which passed the committee unanimously.
Motions for favorable. Seconded. Is everyone okay being recorded in the affirmative? Excellent. 397 passes unanimously. Excellent. Just real quick, I want to go back to Senate Bill 391, and Sandy, I'll ask if this is appropriate. We'd like to, some folks would like to be added as sponsors to the bill. So we'd like to sponsor an additional sponsor amendment. I'm on there. I would like to be on there. Senator Folden, it's 391. Senator Walsweiger, Senator Stidnor, Senator West, Senator Muse, everybody. There you go. All right. Yeah, got it. Is everyone okay with adopting that amendment? All right. We'll now move on to Senate Bill 398.
So Senate Bill 398, this does a few things, so bear with me. Senate Bill 398 requires the Criminal Injuries Compensation Board to pay for forensic examinations and other eligible expenses for cases involving non-fatal strangulation. It also establishes that physicians, other qualified healthcare providers, and hospitals providing specified services to victims in non-fatal strangulation are to provide the services without charge and are entitled to be paid by CICB as specified under the bill. Further, the bill specifies that the Victim Services Unit of the Governor's Office of Crime Prevention, Youth and Victim Services, now known as the Governor's Office of Crime Prevention and Policy, includes the program for sexual assault and non-fatal strangulation forensic examinations. The bill specifies that strangulation includes strangulation that is not related to rape, a sex offense, or sexual abuse. I would note, just as a procedural matter, we are still waiting on budget and tax to get back on the fiscal note. The estimate for the fiscal note estimated in excess of 500,000 on an annual basis.
I wonder, so just it only increases 67,000 for FY 25, right? And then in out years, it's
Right, so that
it could be,
I sort of gathered from the fiscal note that these were based on numbers that Washington State had seen with a version of this in that state. I suspect that the lower fiscal note upfront is related to the bill's effective date. And that just if it's in the middle or end of a fiscal year, you're going to see lower expenditure because it doesn't capture a full fiscal year.
we will wait for approval, but I want to move the bill, so as soon as we get approval, we'll do it. All right, we'll now move on to Senate Bill 442.
Senate Bill 442 increases penalties and points assessments for violations related to participation in racing or speed contests. The bill also establishes a statewide prohibition on exhibition driving and modifies an existing provision on exhibition driving, which applies only in Worcester County. There are two amendments in your packet. The first is number 883021/1. This is from the sponsor of the bill. It strikes a provision which adds a new affirmative defense to the existing Worcester County offense. And the second amendment in your packet is number 193027/1 from Senator Folden. And this modifies the elements of the new statewide exhibition driving prohibition. So specifically on page 3 of 7 of that reprint, essentially the way exhibition driving works is it's defined as the operation of a motor vehicle in a close proximity to a crowd or gathering in a manner that intentionally results in 2 or more of the following, and then there's 7 different elements. So Senator Folden's amendment essentially combines 2 of those elements, which are the engine of the motor vehicle producing an unreasonably loud, raucous, or disturbing noise, and then the other one is the grinding of the gears of the motor vehicle or backfiring of the engine. So essentially the new combined element would read the grinding of the gears of the motor vehicle or the backfiring of the engine of the motor vehicle that results in the engine of the motor vehicle producing an unreasonably loud, raucous, or disturbing noise. And the second change made in Senator Folden's amendment is to element number 3. It's simply changing out the word skidding to the word accelerating.
All right, well, since we're on the second amendment, we'll discuss this first. I did discuss this with the sponsor of the bill, and she's amenable to this, and so it seems like there's after 3 years of debate on this, there's a kumbaya moment approaching here. So good, Senator Folden, then Senator Sidnor, then Senator James.
My apologies, because I thought, I just want to make sure that the House version, or I want to make sure that the towing of the vehicle is not included in the bill, though. Is it? I'm just quickly trying to look over it, so I don't see it.
No, that's a provision that had been in the bill in past years, but
And it was removed.
correct.
Okay, all right, thank you.
So what's the law? You can tow if it's obstructing or if it's like poses a public safety. Can you give it to Folden for a second?
Yeah, so currently you can tow a vehicle if it's, left at the time of the stop in a unsafe location, or if, they request it to be towed, but usually even for like DUIs, the vehicles are left locked and secured along the edge of the roadway. I just don't want to get into a Fourth Amendment issue where for a civil infraction, we're towing or taking somebody's property. So that's all. Thank you.
Regarding the sponsor amendment, am I correct that affirmative defense is being removed because there are no special event zones around the state?
it's being removed just for the Worcester County offense, which applies only in special event zones. It will still exist for the statewide offense, which is similar, though it doesn't apply only in special event zones. It applies in close proximity to a gathering. So it's a similar offense, but the amendment will only affect the Worcester County offense.
Okay, yeah, thank you.
All right, so let's go ahead and adopt, so this is 1930271, Senator Folden's amendment.
Senator James has a question.
Oh, I'm sorry, my apologies, Senator James, my apologies.
Do you have a little dashboard? You can't see it over here. I'm sure, I think you probably can't, right? Is that what it is? No, I'm just curious, in case I'm ever sitting there. So I support the bill totally, but I just need to understand Senator Folden's amendment. Sure, it's great, but I thought that a car or vehicle could make a very raucous, unreasonably loud sound if you took the muffler off. And so I'm confused because 4 then would mean only grinding the gears or backfiring the engine, and that results in loud noises. So that's my understanding of how, in our area, we have a lot of kids that a lot of people take mufflers off or do other things to make their cars obnoxiously, dangerously loud.
It doesn't preclude that. It just doesn't make it that you have to have both. Like, it just puts them all under one subtitle as one element of the infraction to meet the.
No, it reads this way: the grinding of the gears or the backfiring that results in the engine or the motor vehicle making these noises. So in other words, there's only 2 things that have to be combined: the grinding and the backfiring that makes a noise. I'm suggesting that you can have an obnoxiously, unreasonably loud, disturbing noise by removing the muffler. I just don't know why we limited it the way we did, or you could explain to me, because I don't know how this works, but
This was actually just moved down here.
Yeah,
So it still is.
but because now you've combined them and made them Bill, what you've done, Senator Folden,
Mhm.
by combining them, you have made that only loud noises that are done by grinding or backfiring will be one of the elements. However, I believe you can have obnoxiously loud noises done other ways by removing the muffler and doing a lot of other things. Now, I'm not an expert and I know nothing about this stuff, but I do have this experience of cars that are unlawfully adjusted, their mufflers are taken off, they're outrageously loud.
So my understanding is, and Josh, you can correct me if I'm wrong, but because it has the or in there, it simply makes that the whole group as one, either any of those elements within that group that we merged, that would count as one of the then needing 2 of the offenses.
Well, that's true, Senator Folden, but that's not the issue that I'm bringing up.
And it may have been my mistake in drafting if I misunderstood the purpose. It could be separated out so that paragraph 4 would now have 2 subparagraphs. That would be the grinding of the gears of the motor vehicle or the backfiring of the engine of the motor vehicle, semicolon, or subparagraph 2. And then you'd use the existing lines, the engine of the motor vehicle producing an unreasonably loud, raucous, or disturbing noise. So that way, if you had either of them, you would get it, but you would only get one of the 2 elements.
Correct.
Yeah.
That's the intent. If it doesn't
Okay.
read that way, then that. should be-
Yeah, and that may have been my fault, so I
Does that
apologize.
clear up the issue so that if the loud raucous noise is created by the removal of a muffler, an accelerator, or some amplified muffler system, that we would still capture it?
It would.
That's very common.
Yeah, so you would capture it, but if you had a situation where the loud noise was caused by the backfiring of the engine, that would count only as one of the 7 elements.
Correct.
Right. Well, what if you created the raucous noise by removing your muffler? It'd still be just
But
one.
that would, yeah, that would be
Okay.
one element.
Still just one.
And then my second question is simply, again, I don't know how this awful stuff works, but on 5, is the swerving or swaying of a motor vehicle from side to side only possible during acceleration? Is it not also absolutely possible during braking? So I don't know why we limited it to accelerating. I don't know why we limited it that way,
I can answer that one. So
because I've seen it happen in braking.
Well, in braking, if you're moving side to side, you've lost control of the vehicle. So that's not.
Yes, you have.
You've lost control.
Yes.
So the acceleration is the swerving or swaying of a motor vehicle from side to side. The skidding of a vehicle is already covered under subsection 2.
Well,
but
skidding is
that-
not swaying.
Correct. Skidding is a deceleration act. Swaying side to side while accelerating is a different type of action. The laws of inertia, when you're skidding, you are going to scrub off energy because of conservation of linear momentum until that energy is gone. So when that happens, it's a different mark. It's a different thing. So the skidding is already covered under 2. What we're trying to capture is when someone accelerates and they're starting from a stop and the swaying of a vehicle side to side while they're accelerating, that is not a skid mark. That is an acceleration mark. It's captured differently.
I understand the difference between skidding and I do. But I just don't understand why. But if you're telling me that on the laws of physics, that swerving or swaying can only occur during acceleration, I'll drop that question. That's just not my understanding.
Okay. I think that's skidding is already covered. We're trying to capture the acceleration part.
We're trying to cover swerving or swaying, right? Which is dangerous.
During
Because
acceleration.
acceleration isn't inherently dangerous. It's the swaying and the
While-
swerving while the car's in motion.
While accelerating, but the
I
skidding.
hear you. I disagree, but
Okay.
I'm fine that if everybody else likes that, that's fine with me.
Okay.
Just wanted to understand it.
Lots of new stuff today.
As long as the sponsor likes it too.
Do that?
Sorry, Bill, I just didn't know that. Just didn't know.
It's good stuff.
Helpful. Appreciate it. Now I've learned a lot.
Given the dialogue that just transpired, I'm wondering now if we make the change that Senator James was just talking about, and we break out that piece so that, again, the unreasonably loud and raucous disturbing noise, or I guess the lack of having a muffler, and I could envision some sort of a loud pickup truck or something going down the street. You have that, so that would check off one element. Maybe in rural areas, you have people sitting in the back of the pickup truck. I'm wondering, would that then trigger number 6, where you have people riding in an area that may not be designed for passenger transport? Well, I guess the question for council is, would the, I guess, is it what's called a bed of a truck? You can, so that doesn't trigger that. So some old truck, no muffler. Okay.
Well, there's a separate charge there is an independent charge. This is exhibition driving, requires 2 elements. There is a separate charge. Standalone, that if someone cuts a muffler off to intentionally make loud noise, it is a required element. You can stop that vehicle, issue them, you can give them a citation, or you can give them a safety equipment repair order that would require them within 30 days to get that sent back into the administration and have that deficiency repaired within 10 days.
Is that based on it being intentionally cut off?
That's based on if it's intentionally or if it's just aged, that it rusts out so bad that they're no longer maintaining the vehicle, which is where the safety equipment repair orders come in. That is a part of Maryland's law that allows an officer to enforce based on the safety of the vehicle no longer in compliance with the original manufacturer specifications.
Mufflers, okay, thank you.
Yeah.
All right, so that's now a part of amendment 1930271, which we will move. Is everyone okay adopting that amendment? All right, excellent. Now back to the sponsor amendment. I know Senator Sidnor, you had discussion on that. I think got clarification on the one jurisdiction which it applies. I'd like to move that amendment. Right. Second. So now the bill is before you as amended. Motion is for favorable with amendments. I'm sorry. We just did it.
Oh, that
Just-
was-
Yeah,
okay.
yeah. It's been seconded. Is everyone okay being reported in the affirmative? All right. Senate Bill 442 with amendments passes unanimously. Now move on to Senate Bill 774.
Senate Bill 774 establishes the Maryland Entertainment District Security Grant Program to assist community organizations, nonprofit entities, and local governments to fund security operations during times of high pedestrian traffic in entertainment districts from which a higher than average number of calls for police assistance in response to reported crime are placed. It also establishes the Maryland Entertainment District Security Grant Program Fund as a special fund administered by GOCAP to provide funding for grants awarded under the program. Beginning in fiscal 26, the governor has discretion to appropriate up to $1 million to the fund. There is one amendment in your voting packet. The amendment here is, thank you, Amendment 453-129/1. And in addition to the areas that are already eligible under the bill as entertainment districts, this is on page 2 of 4 of the reprint, just under around lines 8 and 9. Provides currently that an entertainment district means a 1/2 square mile area in the state in which either of the following is present: a high density of establishments licensed to serve alcoholic beverages for on-site consumption, or a high density of establishments that regularly host live entertainment for their patrons or members of the public. This would add a high density of establishments that are hookah bars. So any one of those three would qualify as an entertainment district.
I'd like to move the amendment. Second, is everyone okay being recorded in the affirmative? The amendment. All right, now the bills before you. Actually, there's another amendment. We'd like to sponsor amendment.
I actually want to be out of this one, but I also want to be out of this one.
Okay, we'll make sure we'll get back on that. All right, so Senator Folden would like to be added on this. I'd like to be added on this. Senator Walsh-Reicher would like to be added on this. Senator Charles. Senator James.
Does anybody not want to be on?
Senator Kelly. Senator, do you want to be added to the Senate Bill 774? Senator Carter would like to be added.
So it's
Senator,
everybody?
everybody. All right, everybody.
Is there anybody that doesn't? Okay. Okay. No, it's
That-
the whole bill.
That's the whole
is
bill,
a
not just the
whole.
amendment.
Yeah,
Yeah.
no, okay. But everybody else is good.
All right. So now Senate Bill 774 is before you with amendments. Motions were favorable. It's been seconded. Is everyone okay being reported in the affirmative? All right, Senate Bill 774 with amendments passes unanimously. Now we're going to go back to Senate Bill 442. There's an additional amendment that like to be considered, which is a sponsor amendment. I would like to be on that. Senator Charles would be on that. Senator Sidner would be on that. Senator West, Senator Folden, Senator Charles, Senator Kelly, Senator James, Senator
Anybody?
Hughes, Senator Walsh-Reicher, everybody.
Anybody that does not want to be on this one? Senator McKay, Senator Carter.
Everybody's on it. Off, off. Got it. All right.
Except for Senator Carter.
And McKay. That, so is everyone okay adopting the amendment? Everyone's on there? All right, great. All right. All right. So that will conclude the voting session for the day and our work for the week. Just so we're gonna vote on Tuesday. And we're gonna vote the juvenile bill will be the first bill on Tuesday. Okay, so we're gonna vote on Tuesday. We'll get a list out on Monday. But Tuesday, almost everyone we've gone line by line with almost everyone here. We get a couple more people to talk to about that bill to go line by line with. So we'll do that in preparation. But just, yes.
Recess for like 5 minutes, and can you go back and get 3 or 4 of my bills that I need out of there and come back and vote?
We'll have them on Tuesday.
Okay.
Tuesday.
Thank you.
All right, so we're out of here.